All right, terrific. Since it's 2 minutes after the hour, we're going to go ahead and get started. Welcome, everyone. My name is Kirsten Loita, and I head up our University Relations team here at Osage University Partners, which we're going to call OUP throughout this webinar. So I apologize, I'm going to go right into that acronym. Glad to see that so many of you are returning for our second webinar in a series of webinars on academic startup licenses. This series was developed as a resource for entrepreneurs working at companies originated academic institutions, as well as for the tech transfer offices at the academic institutions as a resource for them working with their startup and getting some different perspectives, perhaps from other universities and their startup licensing practices. So next slide. Our three panelists have put together another terrific presentation today. As a reminder, each of our panelists brings a different perspective to this conversation. In order for you to understand what those perspectives are, I'm going to have each of them introduce themselves. Next slide. Nikisha, could you start us off? Nikisha, you're on mute.
Okay, my name is Nikisha Holder. I'm an Associate Director of Licensing at Johns Hopkins Technology Ventures with a focus on life science-based technologies. My perspective today is coming from a private university. I've been a member of the JHU community for collectively 19 years. I'm almost a lifer. And specifically, I've been with Tech Transfer for 13 years. My role here at the university allows me to use the skills and knowledge I've gained through a PhD, my love of science, negotiating, and just doing the deal to make specifically an impact in the healthcare space. And quite frankly, it puts me squarely in the intersection of science and business.
Great. Thank you so much, Nikisha. Lisa?
Sure. Hi, everyone. I'm Lisa Norton, an Associate Director with Commotion, the University of Washington's Technology Transfer Office, and I'll be presenting from a public university perspective. After working at a local biotech startup, I joined Commotion 17 years ago, and my portfolio that I manage is primarily in the medical device space. My interest has really always been in applied technology and how best to bring technologies from the bench to the public. I love that I get to work with really bright, motivated people every day who are working on cutting edge research, and that I get to help them figure out how to take that from a research project to a product. And I'm excited to talk with you all today about some of the ways we can facilitate that success through various agreement types.
Great, thanks, Lisa. Rick?
Hi, welcome everyone to today's presentation. My name is Rick Friedman. I'm the founder of Novus GC, a law firm dedicated to providing general counsel services to emerging technology and life science companies. Today actually happens to mark the one-year anniversary since our launch. We opened our doors on March 23rd, 2020. My various roles before Novus GC included working in big law, in university tech transfer, and in in-house general counsel roles. I was initially trained as a Silicon Valley corporate lawyer and made a career change 16 years ago when I joined UT Austin's Office of Technology Commercialization as a technology manager. I spent a total of 9 years in university tech transfer and business roles and headed up the licensing teams at UT Austin and USC before returning to the practice of law 7 years ago. Since then, I've been on the opposite side of the table, representing startups formed around university IP. Providing general counsel services to companies based on university IP is a significant part of what we do at Novus GC. And so the perspective I'm bringing today is that of the licensee. And I'm grateful to be here with all of you today.
Rick, we're so grateful that you're here to celebrate your anniversary with us, your first anniversary. So congratulations.
Thank you.
And we know that you work with a lot of universities across the country. So great to have you here. So next slide. We did want to just give you a brief overview of Osage University Partners, which we neglected to do actually in this webinar of this series. And we realized that actually there are a number of people who are joining this webinar series who may not actually know Osage University Partners. So we just wanted to give you this quick overview. We're a venture capital fund that invests in startup companies that originate at academic institutions. We invest in all sectors. From those academic institutions, anything that's deep science, something that we would potentially be interested in, and all stages. So anywhere from seed to pre-IPO funding. We're currently on our third fund. Across our three funds, we have about $600 million of assets under management. We've invested in over 100, I think actually maybe over 110 spinouts now from universities, and a number of those IPOs. You know, the market has been terrific for startups in the last few years, and have had a number of successful acquisitions as well. We have a 16-member team, most of which on the investment side have PhDs. So we really go deep into the science, but we're looking at that management team that's associated with the startups when we're making those investments. And so that's just a bit of overview on us. If anyone has any questions about us, always feel free to reach out to me. We'll have our emails at the end of this presentation. And I apologize if my internet's not working that great, guys. I hope that you'll be able to hear everything that I've said so far. All right, so next slide. So you're going to find this presentation on our portal for our partner institutions. The tech transfer offices have access to the OUP portal, which hopefully most of you have signed on to before. We've mentioned this a few times, but for those of you who aren't at our academic institutions and their tech transfer offices, you'll also be able to find a copy of this presentation on our YouTube channel. We'll be posting it sometime soon. This deck will also be sent out to all of the people who registered for this, and the deck will also be on the portal as well. Throughout this webinar, we would love to hear from you. We want your questions. You guys did a great job with that in the first part of this series, so please do also send in questions today. Our panelists love answering all of those, and like last time, if for some reason we didn't get to all of them, we will answer them afterwards. We did answer all of those, and this presentation is actually a little bit shorter than the last one, so hopefully we will be able to get to any questions that come in today. All right, next slide. So this is an overview of this webinar series. Just to remind you again, this is part 2, which is the overall license process and pre-license agreements that we're going to delve in today. Our previous one was kind of this 30,000-foot view where we kind of asked the basic questions. What is technology transfer? Why is this being, why are the opportunities being transferred into potentially startup companies, et cetera. So you can find that on YouTube. If you get this deck, you can just click that link, or on our portal as well. And then we have 3 more parts of this series. Just to remind you, the next part is about the term sheet and financials of the license. That'll be on May 18th. The part 4 is an primer, as well as a few sections of the agreement. And then part 5 is another session on the agreements, where there was just no way we could fit everything that we wanted to talk about with regards to the license agreements into one session themselves. So on to next slide, the overall license pre-license agreements. Actually, I apologize. I'm going to back up for a second, because we actually wanted to remind people about the approach and about why we developed this set of webinars. So all of the people who are involved in this have spent countless hours explaining many of the same policies and provisions to new entrepreneurs spinning out technologies from academic institutions, and why things were happening, et cetera. And so we really wanted to take an approach on this where we were talking about how successful negotiations happen, and having all sides of the parties around this process. So just to remind you, that was our purpose for these webinars and the approach that we took. Next slide. Okay, so now we're on to today's agenda. So first, we're going to start off with the University Technology Circle of Life. This is to give you context again for this discussion about how opportunities are being developed at the universities, where they go to, and what parts of the process each that this fits into, and why we're thinking about all parts of that technology circle of life when doing license agreements. Then we're going to talk about the startup's due diligence and evaluation on the opportunity itself, which is a big part of this discussion, especially with these pre-license agreements. Then the university's diligence on the potential licensee, the entity that is licensing the opportunity out of the institution. And then we'll get into the pre-license and other agreements, including CDAs, letter agreements, option agreements, MTAs, IAAs, and sponsored research agreements, as well as a couple of other things. So next slide. So technology circle of life, next slide, Nikisha is going to review with you and go in depth on our technology circle of life.
So I'm going to kick things off today, speaking about the tech transfer lifecycle. This graphic is taken from the Association of University Technology Managers website, or AUTM, and it outlines the 2019 metric for the different stages in this cycle. So universities are the greatest resources for advancing medicine, agriculture, technology, and public health, generating groundbreaking research that saves lives and improves the way we work, play, and live. Since this is a cycle, I won't speak about necessarily where we're going to start, but today, where it starts, but today I will start with research and development. So there are significant resources to the tune of over $77 billion, which go into moving this cycle along. And both the companies, the universities, and the public benefit from these significant resources. This is where our scientific community performs experimentation and work to obtain new knowledge and findings that lead to new discoveries and inventions. So those inventions are then disclosed to the University Tech Transfer Office, where the technology is evaluated and assessed to determine if it is patentable and/or commercializable. The Tech Transfer Office will have in-depth conversations with the faculty to understand what this technology is, how it was funded, what obligations, if any, are associated with the invention, and we will work collaboratively to determine an appropriate path to protect the invention or intellectual property. Protections typically occur typically via patenting, trademarking, or copyright protection, which was discussed in part 1 of the series. So make sure you check that out. So once it's determined how we're going to protect the IP, the office will determine a strategy to promote that IP via some sort of marketing effort. They will typically post a summary of the technology on their website and search for qualified commercial partners who can bring these discoveries to the marketplace. In that search, they may try to connect with individuals that will be valuable advocates of the intellectual property. It's important to note that the researchers are typically our best promoters for their technology. For the purpose of this webinar, we would have discussions specifically with the faculty about their potential interests in starting a company or being a part of a startup company. So after there is clear interest by a commercial partner or startup company, the parties begin the licensing and negotiation process with the goal of executing a mutually beneficial agreement. Again, I say mutually beneficial agreement. All parties want to walk away from it feeling like they've been made whole. We will speak in detail about that process today and in subsequent webinars. So make sure you check out the subsequent webinars. Although the execution of the agreement seems like it's the end of the process, it's actually the beginning of a long-term relationship between the parties, since there is further monitoring that needs to occur of the license by both parties to ensure compliance with the terms that are specifically outlined in the agreement. So some examples are diligent development of the technology, meeting milestones, making payments, sometimes renegotiation of certain terms based on the development path, life, a pandemic. We don't know what's going to happen, so relationships are important and open communication remains important. Let's note that the right commercial partner can spark more innovation at the university and thus more economic activity. So once the company has the rights to do so, they will begin commercial product development, which can take weeks or can take years, depending on that particular product that's being developed and the stage at which the product is being licensed. Because these are university technologies, this generally means the technologies are at early stages, though this is not always true. But it generally requires that there must be considerable funding and further development, which may include screening, compound identification, prototyping, regulatory approvals, clinical trials, and market approvals before that product actually sees the market. So now we're getting to the end, an ultimate goal, which is getting this product into the hands of the public for use and economic growth. This is where the world benefits. And further, the researchers and universities may realize money, everybody likes money, based on the sales of the product, since each university typically has an IP policy that promotes revenue share with the innovators and revenue share back into the lab, which helps to continue the cycle. So next slide.
I want to pause there. Can we pause there 1 second?
Oh, sure, we can go back.
I want to just highlight something while we're on this slide, which is the magnitude of some of these numbers. We see numbers here: $77 billion, 25,000 invention disclosures, 15,000 new patents issued, close to 10,000 agreements executed. This is 1 year. And this is what the technology transfer offices are managing is basically over decades of these things. So in any particular office, they will be managing thousands of disclosures, thousands of patents, and potentially hundreds or more of licenses. And that's going to be relevant to some of the things we talk about in a few minutes in terms of the infrastructure involved. But this is a fairly large effort involved.
Thank you so much, Rick, for pointing that out. It gives us a little bit of grace on our side.
Absolutely.
The one other thing I was going to mention too is that so this circle of life would be wonderful if it was a self-sustaining circle, but it's not. There's a lot more money that goes in with research grants, et cetera, than makes it as far as those commercialization revenues, et cetera. And that's okay. I mean, part of doing basic research is you don't know what basic research is going to lead to. And that's often what's done at academic institutions, is because it's so cutting edge and you don't know necessarily where the commercial opportunities may lie. But there is a lot of the revenue that is made under this life cycle then does go back into further research itself. And we do have a question, but I'm gonna hold off on this particular question until a bit later in our talk. So thanks, Natasha, for going back. But next slide again. And now we're actually going to go into, and Nikisha, thank you so much for reviewing that circle of life with us. We're going to go now into the startup's due diligence and evaluation, as well as the university's diligence itself. So Rick, you're going to start us off with the startup's due diligence on the opportunity.
Great. I'm not going to read through this slide. I'll let you read through it, but I want to emphasize a few points regarding diligence from the startup standpoint. So now it's the company that's going to be licensed from the university, the diligence you're going to do. And the point I want to emphasize the most is that it's on you to do your homework on the IP, both from a technical and legal standpoint. You're going to be getting it from the university as is. From a technical feasibility standpoint, as Nikisha mentioned, it's typically pretty early stage and is going to need significant additional R&D to get to a commercial product. So at the pre-licensing stage, you may consider if there's any evaluation or validation work that you want to do before taking a license. From a legal standpoint, I want to highlight two major areas of diligence to consider. The first is on the patent side. If you're licensing patents, consider retaining your own patent counsel. The law firm prosecuting the patent is hired by the university and is limited in the type of advice they can or will be willing to provide you about the university patents. Some people find this surprising, but that is the case, and you're really better off having your own patent lawyer. When you hire your own patent counsel, there's a few things they'll be able to do for you. First, they're going to be able to assess the prosecution of the current patents. For example, to tell you what kind of claims you might get, how strong or weak of protection that is, and how the claims address the products that you're planning to develop. They can also advise you on additional areas you may want to explore patenting on your own based on your current or planned R&D activities outside of the university. And finally, they can advise you whether a freedom to operate analysis may be warranted if you want to see if you need rights and other third-party patents to make and sell the products you're contemplating. And whether or not you do a freedom to operate analysis, or called FTO, is pretty industry specific. You're certainly, if you're, for example, developing a novel therapeutic, it's going to be strongly encouraged that you're going to want to know what other IP is out there. In other areas, for example, computing, maybe less so, or there's certainly less emphasis placed on that. So from a legal side, there's the patent diligence, and there's one other point I want to bring up on the diligence from the legal side. And I want to share a university IP story to give you context for why that legal diligence may be warranted. It's a matter that made it all the way to the US Supreme Court, and it's called Stanford v. Roche. And to really oversimplify the facts of the case, It involved a Stanford researcher who, while during his time at Stanford, signed a confidentiality agreement with the company so that he could learn the PCR technique that the company, this was CDAs, had recently pioneered. The confidentiality agreement he signed with the company had an assignment of inventions clause that conflicted with the researcher's obligations to Stanford. Stanford wasn't aware of this, applied for and obtained patents on the researcher's later work, but when ownership of the patents was challenged in the courts upheld the assignment of inventions to the company. And the facts are more intricate than that, but you get the idea that this was a case where Stanford thought it had full ownership of certain patents. The recordation documents in the USPTO said Stanford wholly owned the patents, but ended up, after this being litigated, that this company had actually a part ownership as a result of this agreement that the researcher signed that created this conflict. So if you go to a university now and say, hey, I know all about Stanford v. Roche, I want you to promise me that a similar situation didn't happen with your researchers, they're going to say, and Nikisha's saying it right now, it's like, no, that we can't promise you. We're not responsible. Our researchers are able to go off and sign agreements, and we're not responsible for those agreements. We set guidelines and everything, but we can't be responsible for what they sign. So you go ask the researchers what they signed, and you can go look at that. That's on you to do. We can't promise you that they didn't sign an agreement like the confidentiality agreement in Stanford v. Roche. So that's just from a diligence standpoint of, it's on you to ask those questions. And you can't assume everything. And the universities are being as diligent as they can in this process. They are asking the inventors these type of questions in the questionnaire, but it's still on you to do your further digging. And if you're the researcher or inventor on the university patents, you may want to go back and review the agreements that you personally signed. And as noted on this slide, universities have open environments and are generally supportive of you doing your own due diligence. You just have to ask. And we'll be discussing some of the pre-license agreements today that may be necessary as part of your diligence process. Next slide.
Great, thanks. Next slide, Lisa.
Great. And so just as the startup has a diligence process to make sure that the technology is the best fit for their company, universities also have their own diligence process to make sure that the company is the best fit for their work and the best home for it. And when we're looking at that diligence, what we're checking out is, does the startup team have the experience and expertise to move the technology to the next step? And if not, which is sometimes the case, are they motivated and coachable? Because certainly it's not always the initial startup team that's going to carry forward, but if you have a group of people who are motivated and coachable, even if they don't have that right background, it can still be extremely successful in getting the company just off the ground and started. Since startup often requires the cooperation of the university researchers to have that successful transfer of the technology into the company, it's also really important that the company and the researchers have a good relationship and can establish some good communication, and wherever possible, really have consistent goals with how they want the technology to proceed. We also, of course, review the startup's business and development plan. Importantly, though, this isn't typically a 50-page business plan. It's usually more like an executive summary. What we're really looking to do there is to see whether the development milestones and the timelines are reasonable. To talk about what I mean by reasonable, sometimes we get is a pitch deck that they're using to pitch to investors. Those are great. They're also usually very optimistic, big like hockey stick charts. And what we want to know is the actual timeline so that we can use that to best set license terms and really just to better understand the business itself. We get a question a lot about how important it is to come to the university with funding already in hand. If you have it, that's fantastic. Much more often, what we see is that there's a plan to secure funding. And that's what we're really looking for is, do you have an idea of whether you're going to be pursuing grants, angels, VCs, strategic partners, sometimes a combination of those? And if so, how do you plan to do that? Do you need some introductions from our office? That's really what we're looking at. And of course, we also discuss the minimum viable product with the team. That's to really make sure that we're all in agreement on what the market and application is that the company plans to initially pursue. And again, this guides the development milestones and informs other terms of the license. So while all of these considerations I just mentioned inform what we're looking for, there's also some philosophy behind the diligence. And that's really that once a technology is licensed, it's very challenging to move that technology. to the best of our abilities on both sides, right? We're both doing our diligence. We want to make sure that we have the right fit right out of the gate, wherever possible. And really, to just underscore, the value of the right team really can't be emphasized enough. Having people who are all moving together in the same direction, that have a common goal and a common vision, and who can communicate really well is often the foundation of really the best startups. Next slide, please.
Yeah, thanks, Lisa. We do have a question from the audience about, and I think this is a little bit further afield from what you were just speaking about, but I want to get to it now. Does university IP developed in conjunction with an STTR project require government consent for licensing? Rick, you want to answer that one?
Sure, I'll be happy to answer that. So the facts are that the money came in through the university STTR. The university owns the intellectual property coming from it. Do you have to get the government agency approval to license it? This gets back to some of the fundamentals we discussed last week. Unless Nikisha and Lisa, please jump in with any nuances that may relate to this fact pattern. But generally, the university is going to be able to assert ownership of all things that it develops within the university, and that federal agency approval is not required for any licensing.
Right. So that's exactly right. The intellectual property may also be co-owned if you're a co-developer. And there are terms around the technology and the licensing that apply to the federal government. So the federal government has some non-exclusive rights to the technology. They'll also be looking for any licensee to primarily manufacture in the US. But that's for all federal funding, not just federal funding that comes through STTR and SBIR. And those also will be really clearly delineated in the license. So certainly, if you don't know whether or not the IP that you're interested in has been federally funded, it's a good question to ask. But those are the typical terms.
And for those who didn't see the last webinar that we gave back in January, we went through the government requirements on this, and those are available for viewing now still.
Thanks, Rick. We do have one other question, and I apologize because my internet is going a little bit crazy here, but so hopefully you can hear what I'm saying. But the next question is for technology platforms, how important is it to lay out the business or revenue opportunity when the applicability of the platform is early and can be very broad? Lisa, since you talked about diligence and looking at that, do you want to answer that question?
Sure, it depends on really your business model. We definitely have platform technologies that have so many potential applications that we may license the platform itself non-exclusively, but then have subsequent IP be licensed exclusively for that licensee's field. If really, though, your business model is that you would like to utilize the entire platform, it's possible as well. So it really does relate back to what the company is interested in, what you can implement. And of course, if it's a really broad platform, you're a very early stage startup, and you're hoping to utilize all the different possibilities, there are probably going to be some questions. A good example is a technology out of UW that was developed for use as a marine coating. It prevents biofilms from growing. So great way to not have biofilms grow on your boat, not have to come back in. It was developed for the military, so they don't have to bring boats back into dry dock, but it can also be used for contact lenses, for coatings on medical devices, for coating countertops, the inside of aquariums. And as you can imagine, that whole field from boats to medical devices to fish tanks, that's really broad. So it is a platform technology. We never expected that one startup would be able to capture all of those different routes. And in fact, it's currently licensed to 3 different startups.
Great, thank you.
Sure.
Anything else? Otherwise, we're going to move on. Okay, so now the pre-license and other agreements. Let's go ahead and start on those. Rick is going to start us off with some preliminary thoughts on these types of agreements.
Okay. There's 2 takeaways I'd like you to have from this slide. The first is that universities are complex places with somewhat fixed infrastructure that has evolved over decades or longer. We've seen the numbers earlier that billions of dollars, any significant size university in any year, billions of dollars are running through it for education and research purposes and other diverse activities like healthcare, athletics, and the arts. And the universities have evolved centralized sort of business or administrative functions to make all of this run smoothly and compliantly, because there's a lot of compliance obligations that come in with all the research money coming in. We talked about in the last session, and everything involved in patenting and licensing and being responsible for all the revenue, expenses, and income from that. And so there's these different functions at the universities, and they can be siloed at universities. For example, typical university is going to have an Office of General Counsel, or OGC, that's going to be basically the sole office at the university responsible for legal matters. Patent and licensing is typically going to be solely in the licensing office, the offices that Nikisha and Lisa are in, and they're called different things. And so when we looked at the Circle of Life earlier, we were looking at 25,000 invention disclosures each year, 15,000 US patents issued, approximately 10,000 agreements signed for licenses or options. Those are all handled by that licensing office. Then typically there's a separate office, or historically there's been a separate office that's handling that $77 billion of research that's coming in. And that's the office that handles the government contract grants and sponsored research. And it's typically, they all go by different names, but it might have, contracts and grants in the name, or sponsored projects. Now, some universities have sought to combine those functions. The licensing function and the industry-sponsored research are all external research into one office, but historically they have been separate siloed offices. So you'd go to one office for license and another office for sponsored research agreement. And then, just by way of further example, if the university is purchasing goods or services, that's a whole different office. That's going to go through purchasing and all their processes. So this is just a handful of examples. I've put in here a link in the second bullet here about authority for different type of contracts is dispersed. When I was at USC, we went through a project to just clearly delineate what were the different offices for different kinds of contracts. And you can go click through to see this. And we came up with those 20 different contract types that fell into separate buckets. And you'll see there's half dozen or so offices that have responsibility, and each of them has their separate responsibility for their domain. And so the second big takeaway, so one is universities are complex. They have these complex structures in place to deal with this. And the second big takeaway from these slides for me is that these offices manage a high volume of activity, like we discussed, and they rely on standardized process and forms that have been pre-vetted by the Office of General Counsel and other relevant offices. And that if you can find an established path to follow inside the university to whatever your need is that you have from the university, it will make your life so much better. And trying to trailblaze new processes inside a university for some new process or new type of agreement can really slow the works. Sometimes there is a really compelling reason to do it. Like, a global pandemic, that could be a reason. And the universities all went all hands on deck to figure out how to move things quickly that have been COVID-related research activities in the last year. But in general, I always urge clients that if there is an established path, and I did this when I was in the university also, if there's an established path from the university, it'll go so much smoother if you can follow that path. And for simple agreements like CDAs and MTAs, again, universities deal in very high volumes of these, and I know it makes my university colleagues cringe when they get heavy markups of those, both because of the volume of these agreements they handle, and because the red lines for these simple type agreements often feel unnecessary, and they can derail things or set a difficult tone from the relationships from the beginning. Now, I will say some level of redlining and negotiation is par for the course on licenses, which we're going to start delving into in our next few sessions. But that's not the expectation on simple CDAs and MTAs. And the final point on this slide is that the researcher, the principal investigator, for example, they don't have authority to negotiate and sign agreements on behalf of the university. that authority is in these centralized offices we mentioned. So if you want to get a contract from the university, you ultimately need to talk to these whatever offices are responsible for what you're working on. And they can sign some agreements personally, and we'll be talking a little bit more about that later in the presentation when we talk about consulting agreements. But that's it for the next slide.
Great. I think Nikisha's doing CDAs on our next slide. Thanks, Nikisha.
Yes.
And
Thanks. Thanks, Kirsten. So the CDA sets the ground rules and expectation between the parties for the exchange of information, and it defines what happens to this information once it's been exchanged. So setting these rules and expectation up front facilitates open discussions and hopefully a sense of trust towards facilitating these open relationships between the parties. So a CDA, or confidential disclosure agreements, sometimes called a non-disclosure agreements, are contracts entered into between parties where they agree that certain types of information that pass from one party to the other, they agree that this information will remain secret. So how do universities differ from industry on secrecy? Well, typically the university is more open, whereas the companies want things to remain more secret. So the culture of the university research is open innovation and sharing of information. This is kind of general principles of universities. The concept of secrecy is typically not part of it, how it operates. However, when we are considering things like collaboration agreements or protecting certain IP where we have predetermined that there may be some commercial potential, there may be more awareness around the need to keep that information private until such time as we want to intentionally share it, typically via publication or peer-reviewed journal. Companies tend to always want to maintain secrecy of what's internal to their organization. And again, this is unless they have made a choice to release that information to the public. In fact, industry employees are typically bound by confidentiality of company information based on their hiring contract. So they are automatically bound at the moment that they're hired to keep certain information private unless it's disclosed under a CDA. Also like to note that there are things called Freedom of Information Act or Public Record Acts. And these are acts that provide the public with the right to request access to records from any federal or state agency. These are the laws that keep the citizens in the know about their government and what it's doing. These laws impact some universities, typically state universities, and their ability to keep certain information confidential, including the fact that certain agreements are even in place. And it may require them to provide the whole agreement or portions of the agreement at large to the public. So you should be aware of this. So when you're having conversations about the confidential information that you're hoping will remain confidential for certain periods of time, what logistics that particular institution has to follow and where this information may become public. So let's talk about publications. Well, once information is in the public domain, there's no need for a CDA unless there is additional information associated with that technology that's going to be shared that has not yet been publicly released. So be mindful of whether or not you really need a CDA or not. Why are they used? Well, they're used to protect the party's confidential information. It's inherent in the name. So let's talk about one-way versus two-way agreements. So a unilateral agreement or a one-way CDA will allow a single party to provide confidential information to a second party, whereas bilateral agreement will allow both parties to share confidential information. And there are times where one party is just providing information so a second party can determine whether or not it has further interest in doing something, licensing, collaborating, et cetera. And the other party isn't planning to share any information because there's no need. So again, be mindful of this. So what are the main components of a CDA? Well, we want to define the confidential information. We have to determine whether or not we want to mark all information as confidential, understand who that confidential information is being shared with, setting a term for the agreement and how long the parties can share this information, and then some usual exceptions. So a CDA will typically call out the type of information that's being transferred. and what that information is being used for. This is really important. Is it being used for license discussions, collaboration, sponsored research? And in particular, this information is not for sale. You can't sell it, you can't share it. It's just between the parties for the purpose of that agreement. Many contracts will require that the information when transferred be indicated as confidential at the time the information is transferred. So that could be with respect to a conversation. You might say this information that we're disclosing is confidential. And then you may want to follow up that conversation with an email to say, we disclosed this confidential information in our conversation. Further and more often, sometimes often, the confidential information will be shared as a document. And in those documents, you would want to mark each page of that document as confidential. So it's very clear that it's confidential information. So typically an agreement will allocate the various affiliates and associates of the party to which the confidential information can be shared. So this is just a time saving, cost savings mechanism, and it creates an allowance such that the parties don't have to execute a new NDA for each individual person that's receiving the NDA. So it covers typically the organization, its affiliates, CROs, et cetera. It's important to note that there may be multiple researchers that are participating in these conversations. And so some institutions will have each researcher sign off as read and understood, so they understand it, but they are not signing on behalf of the university, as Rick mentioned previous. Then we have the term of the agreement. So the term allocates the time frame for which the parties can transfer information. But then there's further information in the agreement where it allocates the time frame for which the confidential information should remain confidential. So it wouldn't be uncommon to have a 1-year confidential agreement so you can exchange and have conversations for a year, but that information must remain confidential for 3 years. So again, each agreement will be different. Make sure you pay attention to these terms so everyone remains compliant. Now we have the usual exceptions. And these are considerations that are not deemed to be confidential, even if you receive it under a confidentiality agreement. And these are things like, it's already in the public domain. So you probably didn't need the confidential agreement in the first place. It becomes public due to a third party that's not subject to the confidential information agreement. So parties A and B are having a conversation and party C discloses information to party B. It's not subject to the confidentiality agreement. It's independently developed. And there are other components that you may see. And so there are other components to a CDA. There are lots of different primers out there that can provide you with lots of information about the pitfalls and things associated with a confidential agreement. I encourage everyone to learn more about these things. And so that's all I have today. And Lisa's going to tell us a little bit more on a primer about MTAs.
We actually have a few questions that we need to get to first.
Oh, perfect.
And I think actually maybe Rick wants to make a comment too.
Well,
He wants to jump in.
Yeah, sorry. Just the one comment I wanted to make is that when we talk about the diligence process for the startup coming in here, there are going to be things that the startup may want from the university, like to see an unpublished patent application. For example, there may be a provisional that's filed, and the university is going to require an NDA to provide access to that. There may be data, other things like that that you'd like access to from an evaluation, pre-licensing stage that were required. And then similarly, the university is going to be asking you for a business plan, which may be getting into some intricacies of your business that you feel are important to protect from a confidentiality standpoint. So it is fairly typical to see a mutual NDA at this pre-license stage as part of the diligence process.
And I'll just add on to that, Rick, is that mutual NDAs, it does depend by institution on that. And so you do need to talk with the institution about what they're willing to sign as far as NDAs. But in general, if an NDA does not need to be signed, that would obviously be the preference. But it does need to be signed in the case where, yes, you're still applying for the patent rights, there are things that are not in the public domain, et cetera. So, and Elisa, I think you had a comment too before I get to these questions that have been coming in.
Nope, I'm ready for questions.
All right, great.
I'm gonna,
One-
do it, Kirsten. I just want to finish off the point you made, and point Kirsten was making is not all universities will sign NDAs, and in that case, then you have to figure out how you're going to get the information to the right person, and what level of information provide. But in that case, it could be that the PIs might be able to sign, and you might be able to disclose to them.
And that's for receipt of information from the
Right.
company itself. But I think it's more of the majority that will sign these mutual two-way NDAs. But there are some that it's not part of their practice. So it is a discussion to have with the institutions themselves. So the first question that came, or one of the things that came in was that someone noted that these slides are marked confidential and proprietary, which I thought was a great note, great for someone to notice. This is obviously part of our standard deck, but it is also one of the reasons that people mark things as confidential or proprietary is they don't want people copying them, right? Again, this is intellectual property, even if it's a different kind than necessarily patent rights. And so it is something where people are saying, hey, this is not yours. This is already belongs to an entity. So, but I thought that was nice for someone to notice that.
And we should note, we're not asking anyone to sign a CDA here.
We're not, right.
So fall under fair use if you want to share it with people.
Absolutely. So
And we're actually the opposite. We're hoping, yes, you share and use this information.
we hope you share this. Absolutely. So you have our express verbal permission that we now granted on that. So one question that came in, and Rick, and I'd like to direct this one to you just because you're the attorney on the team, is how enforceable is a CDA or NDA? And perhaps you could give an example or two.
Oh, they're very enforceable. I mean, you see large trade secret litigation going on all the time. There's lots of issues in terms of enforcement, in terms of being able to establish that how that something's going to fall within the scope of it, and figure out that it was actually breached. But I don't think there's any question that non-disclosure agreements are enforceable. It's just, the circumstance, whether you're able to. So this is a much more complicated discussion. Like if you wanted to say, I have an idea and I want to protect that idea, like ideas can be really hard to protect. And so there is this level of what is the type of thing that you can protect under a confidentiality agreement, and that's a whole longer discussion.
And trade secrets is a good thing to bring up as well. I know for the University of Washington, and I think for most universities, we're not interested in having your trade secrets. And really, as the company, you shouldn't be interested in sharing them with us. So any conversations that you can have that are above that level where you'd have to share a trade secret, fantastic, let's have those conversations. But when it gets to that point of IP, it's too challenging for us to assure that we can hold it as trade secret, especially in a public university, but that's not just for public universities. And if it's really that essential to the company's IP, don't share it with us.
That's exactly right. And I would say typically we see that being put into agreements and they are automatically redlined out.
Yep.
So one thing I want to highlight from the licensee standpoint is that when you're signing the agreement, you should take it seriously and to consider what kind of confidential information you actually want to receive from third parties. Because once you receive it, if it truly is protectable confidential information, that you may be tainted by it. So it is a conversation I'm having with startup clients all the time in terms of just being wary of the type of things you're bringing in. And if it's sort of for too close to what you're actually developing, think whether you really want that information because of the obligations that may be coming with it.
And I think that one thing that maybe startups should know when they're talking with investors is that investors, for the same reasons, are very wary about signing CDAs because they receive so much information. And they also don't want to kind of taint the waters of everything that they're learning too. So but just, you need to talk with the investors about whether they're willing to sign those CDAs too.
And what happens often is that there's a discovery process. And at the front end of the discovery process, it's best if you can start it without confidential information. And then certainly with investors, because if you send an investor a CDA from day one, that's probably not gonna fly. So sharing non-confidential information first, and then if they're serious and they're very excited about the opportunity, then you may say, okay, well, you wanna deeper dive, deeper look at the technology, then there's going to have to be a CDA in place.
Yeah, good advice. And then we have one other question, and I'm not sure how to answer it, so I'm hoping. It says, during the option agreement phase, when are three-way CDAs needed? And I don't know about three-way CDAs.
So I'm going to make an assumption, and whoever is asking the question, please correct it if it's wrong. Sometimes when people ask us for a three-way CDA during the option process, it's because they have an interested investor. Our CDAs happen to cover for that eventuality, and so would the confidentiality terms within an option agreement if you don't have a CDA. And they allow you to share information with a potential investor. And we do it for that reason, so that if you're presenting to VCs, angels, whoever it may be that you're looking to for funding, that you don't have to have multiple agreements. If that's not the question you're asking, let me know. There are other situations that aren't as frequent, that may be because you have a development partner or another entity gets involved. But I would say that by and large, it's because you have a potential investor.
Great. And the person who was asking this actually did clarify it. It would be in the case of an industry partner, potential industry partner, which is, yeah, usually covered under that potentially that can be added into that perhaps two-way CDA.
Yeah.
Yeah. Great. All right. I think we're done on NDAs then, unless anyone had any more further comments, and we can move on.
Great. Next slide, please. So material transfer agreements. This really is a great way to facilitate research and the evaluation of research materials. And to have that transfer between organizations, we execute quite a number of material transfer agreements, or MTAs. These are contracts between institutions or corporate entities, depending on where the materials are coming from, where they're being received. And they serve to protect your intellectual property, whether you're the provider or the recipient of those materials. Importantly, I really want to emphasize this. When we're executing MTAs, those materials are being transferred for research use and not for commercial use. If commercial use is required, meaning that you'd like to use and sell it commercially, that would occur through a follow-on license agreement. So if that's the case, you would have both an MTA and some form of license. I've listed some of the materials that we most commonly transfer under MTAs. This is by no means an exhaustive list, but some of the most frequent ones are cell lines, bacteria, antibodies, transgenic animals. And it's just one example of the types of materials transferred and the importance of doing so to drive research. In 2 weeks last March, our agreements team negotiated more than 50 MTAs to transfer de-identified COVID samples to research groups around the world to expedite vaccine and diagnostic development. And that's just to underscore that an MTA can be a really powerful and extremely useful tool, and a great way to be able to get the right materials to your organization to speed up your research. So the MTA is going to outline the nature of the materials and their transfer, but of course it has other terms as well. It's going to limit the liability. Just as Rick had been mentioning before, materials and technology gets transferred as is. So there's a limitation of liability around that. And for the recipient who's going to be doing their own research, they have their own liability around the work that they'll do that's not falling under the provider's liability. Again, these are usually freely done transfers. There may be some charge for preparing the materials, but that's nominal. And so the compensation for these agreements is typically in crediting the developer of the materials. Somebody's transgenic mice who get used over and over, they'd like to be credited for the work that went into developing that mouse line or cell line or antibody, whatever it may be. MTAs also will frequently limit the use and further dissemination of the material by the recipient. This is really important, especially if you have researchers who are moving from one university to another. That happens often, where we've had either new university researchers coming in, or some of our researchers transferring to another organization. They're going to need a new MTA at that new organization to cover the next transfer of materials. The MTAs also address publication rights, just as CDAs do, confidentiality, so some of the terms that Nikisha was just talking about. And it'll also talk about rights, if any, to inventions and research results. And so you can see there are a few different terms here, but they're all pretty consistent. And because of that, there are two standard agreements that I'm calling out here that can be used for really the majority of material transfer cases. And the first one is from the NIH, National Institute of Health, and it's called the Simple Letter Agreement, or SLA. And the links are below if you'd like to check these out. And it really is exactly what it says. So as the name implies, simple agreement. It's just a one-page document that specifies that the materials that are going to be transferred will be used either for teaching or for nonprofit research and won't be used in human subjects. And so if your organization and your proposed research can fall under that, really simple way to go. If it doesn't, that's fine. Research institutes and companies can also use a similar agreement called the UBMTA. That stands for the Uniform Biological Material Transfer Agreement. And this can be used to transfer patented or non-patented material. It can be used by nonprofits or for-profit entities. And an organization doesn't have to be a signatory to the UBMTA to use it. However, if both entities, both the provider and the recipient, are signatories to the agreement, then you can execute an implementing letter for the UBMTA, which is very similar to the simple letter agreement that I just described. And if you want to know whether the material that you're requesting information from is a UBMTA signatory, there's a list of the signatories that can be found on the Autumn website. So same link that I'm sending you to for the agreement, there's a similar link that will tell you about the signatories. So both of these, very straightforward. These are usually documents that can be executed, within a day or a matter of days. But there are always going to be situations that aren't going to be covered, or somehow you need a more customized agreement. That's absolutely possible. We just want to point out that if that's the case, those negotiations typically are just going to take a longer time because they're not falling under one of these standardized formats, and therefore they're just going to need some additional review.
Lisa, we have sorry.
I just wanted to throw something in there that Lisa mentioned these two quick types of MTAs, and because of that, and the need for expansive sharing of materials specifically between universities as well as between universities and commercial partners, that our universities do a multitude of MTAs per year on the order of magnitude of 2,000, 3,000 to 4,000 per year. So just to let you all know, you're not the only MTA that's in the queue. So sometimes patience is needed, but I think most of the time, these simple MTAs can be turned over within 3 to 5 days.
Yep.
That's really good to kind of put the time context on that as well. I think just because I know that everyone tries to get them done really quickly because people want the materials and they realize that. We do have a question from, I think it's a researcher. And there's two parts to this question. So the first part is, do I need an MTA from my previous institution if I was the lead inventor but now moved to a different institution?
Yes. So I will say, researcher, if you don't currently have that agreement, you find yourself in the position that most of our researchers who transfer from one institute to another have also found themselves in. It can be a pretty straightforward process, but yes, ultimately to make sure that all the rights are covered, that the university or organization where the materials originated knows where those materials are, and that your new organization knows what rights those materials are received under. That's really important. And especially if then you go on to invent around or beyond those materials, that agreement is going to be really important to track the appropriate rights. And so much better to do so earlier than later. But I'm sure Nikisha has had the same experience that we have where, in retrospect, it's at the point of maybe a new invention where we're going back through the materials timeline and realize that we need to have another material transfer agreement in place. So if you do it at the outset, great. If we need to do it in retrospect, it's something that we've certainly done.
I agree, Lisa. And I would even say that many of the tech transfer offices may have a mechanism in place. So if you know you are leaving one institution and going to another, reach out and let them know, and they'll provide you with this packet of information. Because, go through your freezers and look at everything that you have, send it to us, and we can try and figure out whether or not all of these have been developed at this institution whether some of them were developed at other institutions and they can put together a comprehensive MTA package from one institution to the next, as opposed to doing it piecemeal.
Yes, definitely.
Rick, were you going to add something?
I recently had an experience that hit this exact issue where we're nearing the end of the license negotiation, and there was some materials that were needed to go, you know, it was a patent license plus those materials. But then when we got down to the materials, it was the researcher had brought them from the prior institution. There wasn't paperwork, and it was, you know, a bit of a last minute scramble, which can gum up the works. Ultimately, in that case, decided not to transfer the materials. But
all right, and then this goes along with that last question. I think I know the answer based on what you guys said, but I'm going to ask it because I think it is important. So if some other investigator approaches now this investigator for a reagent or cell line, who provides the MTA for that, the old or the new institution?
It's almost always going to be the old institution. They have the original intellectual property rights. So I'm not going to get into the nuances because honestly, this isn't my area of expertise. It's possible though that if, so let's say researcher B who wants the materials from researcher A, if those materials have been altered, developed at your new institute, and researcher B now wants the original materials that have had this additional development, you may actually need permission from both, or you should need permission from both organizations. And while this sounds complicated, and you know, honestly, sometimes it can be, most of the time, this can be a pretty straightforward agreement. And I appreciate that you're asking what the correct way to do this is, and just know that your new home institute hopefully will have done this before, having been in the same situation. And if not, please have them reach out to me. We've certainly had experience in helping researchers figure out how to make sure that they have that right chain of materials permission as they do travel around. We don't want to stop anybody from traveling. We do want all the organizations to know the origin and the rights around those materials, just to make future agreements easier.
And then there's a follow-up question from the same person. For intellectual discussions with another investigator, do I need to let my institution know of dialogues exchanged?
That would be a CDA and not an MTA. And again, only a CDA if the information that you want to have is confidential. If it's covered in a paper or a presentation or a patent, anything that's publicly available, you don't need a CDA for that.
It sounds like this is mostly between scientists themselves, so scientific exchange is going to happen.
Yeah,
so
sure.
say something.
Great question.
I think that's a good segue into the next slide also.
Yeah, good point.
It does. It's perfect. Thank you so much for the person who sent this in. I'm gonna read the question, but know that you may be answering this right now, Rick. So, regarding MTAs, if the material belongs to an institution from where the faculty came from, material belongs to the old university, how would you structure the MTA?
I'm going to let Lisa or Nikisha. So just the question was that there's faculty member transfers.
The MTA for if the material belongs to an institution where the faculty came from.
And then how would you structure the MTA for like the industry person who wanted to use it?
I think so, yeah.
So I think it would depend on what the use of that material is. So if the use is for internal research, then typically all of our MTAs would allow for further transfer of the material for internal research. However, if it's for commercial development, typically we would refer that industry partner back to the original conveyors of the material to get an MTA that has maybe more aggressive terms around commercialization or a license if that's needed. So it really depends on what's the purpose of the transfer, what the material is going to be used for, things of that nature. So again, conversations need to happen in order for tech transfer representatives to fully understand how to do things. And open communication about the real intent is important because it could save so much time with respect to how we direct it. So there have been so many instances where we have a conversation, we think this is the purpose, but after further conversation, we find that there are additional purposes that weren't contemplated in the initial conversation. And now we need to now refer the commercial entity to another institution, and there might be frustrations, et cetera. So again, having open communications about what the material is being used for can certainly help speed up the process.
Right. And one thing that I want to add that I think maybe I hadn't fully described before is that in the MTA, there are going to be limitations on how the recipient can use those materials. So often it's a full stop that researcher, that one specific researcher or lab, not even the entire university, can use those materials. And if the materials need to be utilized by any other researcher or for any other research purpose, there will be, it necessitates another MTA for those same materials from the provider. So this is all just to make sure that you're keeping in compliant and that the university is keeping in compliant with what they've already agreed to.
Yeah, and the university also is trying to keep track of where their materials are going,
Yes.
to the best of their abilities, although.
Sorry, and actually the person was clarifying that should the MTA be initiated by the old institution? Does it matter who the MTA is initiated by? Because there's the receiving party, the party that's giving the materials, and there's the receiving party. Does that matter? Initiation. Who initiates the MTA?
It's going to be signed by whoever's transferring the materials. And again, Lisa and Nikisha, please correct me if I'm wrong, but the party actually transferring the materials is going to have to sign the material transfer agreement. There may be a question of whether consent is needed from the initiating institution on that.
Yeah, I would say that almost always, if not always, the provider of the materials is going to initiate the agreement. And I think that's, so it may, because they'll have the best idea of what the requirements are around that material, whether the material is still available, all those different components. And so that's typically how it would initiate. Certainly the intended recipient can make the request and ask them to initiate the MTA, but that's usually how that process is going to go.
And we have one more question on MTAs, and then I do want us to move on because I know we only have 20 minutes left and we still have 3 main topics to cover. What do you advise on things to take note on dealing with multi-party MTAs? Perhaps it's not just the university and one other entity, but there are multi-party MTAs. Is there anything particular that you would like to take note on for people?
I think just read the agreement carefully, know what your rights are under that agreement and what the limitations are. That's true for any agreement, even if it's just a 2-party agreement, but becomes or can become even more important when you do have a multi-party agreement, especially if you may want to use those materials in different ways. Just really from the outset, know what your rights are. And if they're unclear, make sure that they're very clear, because you're going to have multiple parties who are relying on the same document instead of just 2. And of course, those conversations can get more challenging with more parties. So do everything that you can to have it be as clear as possible from the outset.
Great, thanks, Lisa. We're going to move on to interinstitutional agreements now, because we're going to run out of time in 20 minutes.
Okay, I'll be quick on this one. So as you've heard from the conversation, there's a lot of collaboration among institutions. They're sharing materials, scientists are in dialogue, and they're getting joint grants on things as well. And there is a significant amount of collaboration among different research institutions. And as a result, there's joint ownership of the patents and other IP that comes out of it. And from the licensees, the startup licensee standpoint, this all may be happening seamlessly in the background, because at the end of the day, you're probably just going to be negotiating with one lead institution. And typically, if these are one-off relationships, there'll be an interinstitutional agreement or IIA that's been negotiated, that's put in place between them. And so if that's all in place, that's all great for you as a startup. You don't need to worry about that. But what will happen is that the non-lead institution is going to have a set of requirements that are going to be in the license. And those often are explicitly in the IIA, and they're often going to have review rights over the license. So these are things that all add to the process of getting the license done. And also, when you want to make change to what might be standard indemnification terms or whatever else, that the institution you're negotiating with is not going to have authority over that they're required to put these terms in. So if you want to change these, it's going to mean going back to the other institution. So You know, and it's not, you know, it's not just actually these collaboration where you end up with this joint IP. You also have faculty members with joint appointments, and or maybe they're an HHMI appointment as well. So you end up with a fairly significant number of situations, and we see a lot of licenses where there isn't just the lead institution policies we're dealing with, but there is another institution with rights that has mandatory terms in the license that you know, cast influence over the licensing process, and certainly can add time to the time frame of getting the license done. And as noted here, this depends on the institutions. If you're issuing equity, sometimes you will actually have to issue equity directly to the non-lead institution as well, depending on how they've decided to manage that. Just pointing out here that there is a model interinstitutional agreement if you're interested in looking what these look like. This is a topic near and dear to my heart, and Kirsten's as well. I think we met on this Model I project, working on it. I think it was like probably like 8 years ago or something that we started on this project. So now there is the Model I that's been established as a starting point. A lot of it's not always used, but when institutions don't have a history between each other, they will use this, and over 60 institutions have signed on to it now. We can go to the next slide. Oh, and this is okay. So sponsored research agreements. Earlier, we showed the circle of life, and we talked about the $77 billion of external funds that go into US universities for research each year. And while the majority of that is from federal agencies, a $5 billion slice of that is from companies that put money into universities for sponsored research. So why would a startup care about sponsored research? The first is that in their startup phase or after, they may want to leverage the university facilities, labs to further what they're doing. And so they may want to put money into the university to carry on that activities. And that can be fairly common in the early stages of a company before it's established its own facilities. And the second is that it's also helpful to understand how these sponsored research agreements work, because another company may have some rights in the technology being licensed if they sponsored research that led to the development of the technology. And so laid out on this slide, the general parameters of how SRAs work. You know, the first important idea here is that it's time and materials basis, and that there's a budget which is developed by the PI, typically based on the actual people involved and like any equipment purchases or any other costs involved. And that it's also important to understand that the university adds on top of that budget an overhead rate that they do for all contracts and grants and sponsored research contracts. And that overhead rate is practically always above 50%. And this varies from university to university, and each university will have its standard rate. So this is a good thing to be aware of when, you know, as these budgets are being developed and what the cost of it is going to be. And another point I want to highlight here is that paying for research does not mean you own the results of the research. The way you have this idea of ours, mine, yours, what it means is if the company develops IP, the company owns it. If the university develops IP, the university owns it. And if it's jointly developed by the university and the company, then it's jointly owned by the university and the company. So, and this surprises a lot of people. That's why I want to highlight it. Some people say, hey, I'm paying for the research, why don't I own it? That's not standard here. And there's a lot of reasons. A lot of them are the reasons we discussed in our first presentation, but the universities will assert ownership in virtually every case over work that's done by their researchers. But the sponsor typically will have a right to negotiate an exclusive license to the IP generated under the research. So if you've paid for the research to the extent that the university has the rights, they will allow you the right to negotiate a license to it. Now, if, for example, you're doing this in connection with getting a license, you're saying, hey, we're going to license this intellectual property, but we'd also like to spend, you know, a few $100,000 in terms of putting some research money back in the lab because there's important work we want to get done. Some universities in that case will allow the new IP to flow in to the license, but this really varies on an institution by institution basis. Some will allow it, some will require negotiation, and sometimes it may just depend on what it is that the new IP is that comes out of it, you know, how closely it's related to what's been licensed. And this is really the exception though. In the absence of existing license agreements, there are a small, sort of a handful or so of universities that will actually pre-agree to or set parameters on licensing terms when at the time they're entering into the sponsored research agreement. And this really is more the exception than the rule. And this gets to kind of like issues on the law regarding interest-free bonds and BIDOL and a lot of considerations that it just works out this way, that the universities will not agree. And there's a couple ideas in this slide. You may hear terms used like background IP or foreground IP in talking about sponsored research agreements. Background IP generally means IP that exists before the research product or is developed outside the research product. And foreground IP is IP developed in the conduct of the research project itself. And sometimes people refer to this as project IP. So these are terms you may commonly hear. And it's incumbent on the sponsor to ask whether there is background IP. So if you're doing this research at the university, it's good to know if they filed some patents already on the work that you may need to exploit, to commercially exploit what may come out of it, and to ask for it to get disclosure, and then figure out if you need to negotiate a license to that background IP as well. Practices vary from university to university, but some will give what's called a NERF, a non-exclusive royalty-free license, as part of the sponsored research agreement to use background IP or foreground IP for internal R&D purposes. And the last thing I want to comment on this slide is gifts. Gifts are another mechanism for companies to put money into research labs. And this is, in some industries, this is actually more common than others. The essential characteristic of it being a gift is that it has to be a true gift, and that the sponsor can't get any rights back. And there's sometimes, though, it's in the selfish best interest of the gift giver, even though if there are no rights back. One thing about gifts is they will carry overhead rate, but lower than the sponsored research rate. So more of it gets used for actually research purposes. And sometimes there may be an expectation, for example, that the results are going to be published. So it might be put out as an open source software basis, for example. And that doesn't mean that the donor has exclusive rights to it, but they will get access to at least what they help fund. I don't have anything more if there's any comments on this slide.
We have about 11 minutes left. And so what I'd like us to do is get through the next 3 slides. And we do have a couple questions that came in about IAs that I'm hoping that we can get to as well, but we're going to probably put off the consultancy agreements and stuff till the next webinar. But I wanted to make sure we get through letter agreements and option agreements really, at least preliminarily, and see what we can get through on that too. So, and one thing I was just going to mention really quickly, contract research is different than sponsored research. So make sure you differentiate between the two. Contract research is very directed as far as the focus and what people are doing. Sponsored research is very broad. So also think about that when you're thinking about sponsored research agreements. Receiving preliminary rights to that intellectual property from the universities. So we're going to start off talking just about letter agreements are one way to do that. These are very, very simple letters that the university and the company sign that are usually, just going to be like I said, about 2 pages. They're going to be shorter text than a full option agreement. There's usually not an option of fee associated with them, but it may say that they're covering costs incurred during the letter. They're not as common as option agreements, but there are some universities that do use them in lieu of options. I think I've seen the trend kind of, there's been a wave. Let's use letter agreements. Let's not use letter agreements, et cetera. But options definitely still seem to be more common, in part because they're not meeting the expectations of what is needed for the startup company themselves. So just FYI, there are examples out there of letter agreements. It may be what the university prefers to use versus options, but more universities seem to use option agreements. So we're going to talk now for the next, for most of our remaining time about option agreements, and then get to some questions. And Nikisha, you're going to just talk about what option agreements are.
Sure. So an option agreement is a written contract that allows the commercial partner an opportunity to evaluate the technology and its value prior to finalizing the decision to enter into a license agreement. It's really important to note that the option does not convey any rights to commercialize the technology. I like to think of an option as doing a test drive or signing a lease agreement to a car to determine if you really want to buy it. So what is an option? So an option may be either an agreement or a clause within an agreement. We've talked about some of this already, which gives one party to the agreement the right to acquire a particular right, perhaps a patent right, a copyright, or a material right. So this is typically done in a standalone agreement in which the main subject matter is granting the option to take a license to a specific patent application or copyright or material. And this is not part of a larger contract. And again, we've talked a little bit about this. This option agreement will typically allow the startup or company, if it's a startup, opportunity to fundraise maybe for a year. So you're looking at it and you're trying to figure out, how am I going to fund it? Let's get a signed agreement to fund part of the next stages of research. Also to perform due diligence. Does this thing work the way we think it's going to work? Let's do some preliminary research to identify whether or not we can perhaps identify compounds or something for a target, et cetera. Require another party to enter into an agreement in a specified form or negotiate the terms of a further agreement. So Rick really alluded to this in the context of a sponsored research agreement or even a collaboration agreement. And there may be an option as part of this, which gives the sponsor a right to negotiate the terms of a license agreement for that IP that's developed during the context of that sponsored project. And then finally, to evaluate materials, products, or assets to determine to enter into further agreements. So this may be known as an option evaluation or simply an evaluation agreement, where one party will provide a thing, something to a second party to evaluate, to make sure it's really working the way they think it's going to work. For materials, is the materials working in the assay that has been developed? And again, this party is determining whether it wants to license it. I'd like to note that sometimes there are financial terms for a license that may be included in typically the standalone agreement. And basically, you may have this phrase bandied about. Do you want an option with or without terms attached? And that means, do you want kind of the financial allocations of the license agreement attached to it? And we'll talk more about kind of what those terms look like. They would be very similar to what you'd see in a standard term sheet. So unless there are other comments on this, I think Lisa will now provide us with information about the components of the option agreement.
Great, thanks, Nikisha. So I'm going to try to very quickly go through the key terms of an option agreement. One that Nikisha just mentioned is the option grant. So what are the rights that are being granted? Usually under an option, it's an exclusive grant of rights to the technology to really facilitate that review by the optionee and facilitate their evaluation, and also to act as a standstill for the term of the agreement. That term of the agreement is usually a year or less. That's generally expected to be sufficient for the company to consider the technology and to know whether or not it's a good fit for them. It can be shorter, occasionally we extend it, but usually a year is pretty much the sweet spot for that. There's also an option fee that's reflective of the duration of the option and the value of the technology. These can certainly vary because of those reasons. And one of the things that I wanted to make sure that we highlight is that the option also will include the payment or prepayment of any ongoing IP costs that happen during the option term. So this isn't looking backwards at the costs that have already been incurred or past the term of the option, but it can be really important for the company to know, is there a patent portfolio? Is this just one patent? Is that one patent going to convert, or is there a nationalization? Because that will cause those potential costs that happen during the term to vary widely. So please make sure that you ask those questions and have a really good understanding of what could happen during that period of time. The option also is going to include standard terms such as confidentiality, just as we've been discussing today, and indemnification, which is a bigger topic. So we're going to review that in more detail in one of our subsequent webinars. And also, as mentioned in the previous slide by Nikisha, sometimes a company is really interested in taking a technology for an even shorter test run. This happens more often with software, devices, and research materials where there's an element that somebody wants to actually have in their hands, have in their lab, and to test out. And if that's the case, we negotiate an evaluation license to enable the company to consider the fit of the technology with their organization before entering into a broader option or license. It can really be a great de-risking tools, and these are generally for a shorter period of time, maybe on the order of 2 to 3 months. Quick.
Thank you for getting through that so quickly. So we're going to go to the next slide just to show people some option agreements where these are ones that are just online that some universities just have their template online. There are other ones out there. What I'm going to do is, because we only have a couple of minutes left, I'm going to try to have us do some lightning round on the questions that have come in. But I did want to note that someone pointed out that letter agreements are also called letter of intent. So you may see that come across your desk as you're looking at things. The other thing is that for sponsored research in particular, but also just for startups in general, that may trigger a conflict of interest policies and a conflict of interest review. So that's something that we talked about in the previous webinar, but something else to keep in mind. So Natasha, why don't you go ahead and take us just to the last slide so people can actually see our panelists' email addresses in case they have further questions after this that we didn't get to today. But like I said, whatever we don't get to into this lightning round of questions, you can email people here. Just a reminder, we do have that next webinar on, now I can't remember because it's on the previous slide, it's March 18th or 19th, I think. That will cover financial terms in the term sheet of the license. Thank you, Natasha. And Natasha is also going to put in the chat a link to the survey, but you also, I think, should be getting that as you leave this presentation today. All right, so here is our lightning round for questions. Can you explain who data is owned by? Is it owned by the sponsor or the university under a sponsored research agreement? Nikisha.
Oh, I think this will typically depend on what's agreed upon at the onset. So I think most of the time in sponsored research agreements, the data that's generated under the sponsored research is typically owned by both parties. So each party can do whatever it is that they want to under the agreement. But some agreements may say if it's generated by the university, it's owned by the university. Again, Rick spoke to this. It depends on what the contract says. So be very specific in reading your contract and understanding ownership.
Okay, great. Thank you, Nikisha. Next one's for Lisa. Have you seen compensation as part of an MTA be used to offset IP expenses during the term of the option?
I haven't seen that. It doesn't mean that it hasn't occurred. It just means that I haven't seen that. That's primarily because there isn't a cost for many MTAs. It's again, it's going to depend on the materials and the challenge in creating those materials or in shipping them. But usually what's happening there is just to compensate the lab back for their direct costs. So it's fairly unusual to have a money-bearing MTA from the outset, and then to have that money be directed to IP isn't something that I've seen.
Okay, great, thank you. And then Rick, we have a couple questions on IIAs, and there's one more beyond this that if people can stay on for a couple more minutes that I didn't get to, where someone has seen a trend that the non-lead party in the institution refuses to share patent costs and wants the lead to bear the expenses up front and get reimbursement from license agreement, if any. Do you have any thoughts on that? Did that come up during the model IA process about, if you're not the lead institution?
Well, I think that was actually, and I remember one of the most difficult issues we addressed was what happens if they've committed to pay and stop paying. That's a very complicated issue. And there's actually in the model IA, there's an extensive footnote on that point that I remember from several years ago preparing that. So what I'd say is, regardless of what the IIA says, it's often the fact that the lead is just paying it and not getting reimbursed. That's just my personal experience. And I don't know if other people have other experiences, because what's going to happen is that the lead often will have a bigger stake in it. There's certainly going to be some cases where they're getting reimbursed, but it really gets negotiated from time to time, differs because, for example, the lead institution may have a much bigger patent budget and be able to afford foreign nationals, and it's going to go do that. And maybe as a result, they're going to get a bigger slice of the licensing income. So it really depends. And what happens when the license is executed, those get recovered first, and that the institutions get made whole when that happens. But the practices really vary, and I think the de facto is that the lead institution ends up paying most of the time.
Okay.
Yeah, I would say that just very quickly, we see the same trend, but it also means that IAs get instituted later because that lead institution is going to want to make sure that they have a potential licensee before they're trying to take the time to then make sure that they have coverage of all the rights. So just be aware of that balance as well.
Agree, Lisa. Delayed IIAs.
Well, and so this goes to the next question about the working with non-US entities. They don't seem to have sometimes a lead institution approach, but rather a joint ownership approach with all parties participating in the license agreement. Thoughts on that?
I think that relates back to how intellectual property is managed outside the US. So typically you need to have the co-owners be in alignment about licensing. It is a much more balanced system in that in the US, if you have two co-owners, they can license separately. You don't have to jointly combine those rights. But in Europe, for example, if you plan on licensing a technology that's jointly owned, there does need to be an agreement in place. And so I think because of that, because the parties really can't act independently of one another, they typically come to those agreements from more of a equal place.
I just have one more comment. I'm not sure if he's still there, but Scott Hamilton from Columbia was in the audience today. And Scott was in Columbia when we were doing the Model IA project. It's not unrelated to this, but there's a simplified approach that was adopted by Columbia where instead of doing a full IIA at the outset, they entered into a simple agreement just to kind of allocate the costs and give one party the lead. So that's a little bit of a shortcut and a simpler way for universities to reach agreement earlier without going through a full IIA. And I think a lot of people have taken advantage of that.
Well, there's one more question left, but I do want to thank all of our attendees who actually stayed on this entire time. It's been over an hour and a half. Thank you so much for sticking with us. This is being recorded for those who did have to leave. So hopefully they'll get to be able to watch the rest later since we are now officially over time. The last question is an interesting one, and I saved it. It's actually the earliest question, but I saved it because I thought, oh, maybe it'll end up relating to something we talked about. And it'll actually probably relate to things that we're going to talk about in the future, but I'd love for you to think about it, even if you don't necessarily have an answer for it right now. And this person would like to learn about shareholder licensing. And by that, they mean offering the IP holder a share of the profits of commercialization in lieu of cash. So kind of perhaps a broader, not just an earned royalty, it sounds like, but something broader across the commercialization, perhaps of the company itself. Is there something that you guys have seen on this or would like to comment on it right now, or something to think about also for next time?
Really rare. I've seen that.
Yeah,
So
I would have to think about that. I would have to think about that.
Yeah. And I think the way generally to think, I've got one case where I've done that and it was pretty contentious, actually, that was even requested by the institution. I think, but generally I see the licenses as really a lot of risk sharing anyway, because then I think when we get to the licensing terms in our next session in May, you're going to see that typically there's not a lot of upfront cash. Typically, there is a partnership where the university is going to share through the royalties, through sharing sub-licensing income, through milestone payments, and often for startups, equity. So, to some extent, the universities are taking that risk with the startup as well. So I feel like that's embedded already in a lot of this. And the universities aren't expecting startups to, as far as I know, write $1 million check on day one.
That's right.
Right. Well, and so that's a great lead into our next conversation. Thank you, everyone, for sticking with us for so long today. Obviously, we thought this was going to be a shorter one than the last one. We were wrong, but that's a good thing. That's a good thing. And thank you to our panelists. Thank you, Nikisha. Thank you, Lisa. Thank you, Rick, for all your hard work in making this presentation and being here today and answering all the questions. And we look forward to seeing everyone in another 2 months then. Take care.
My pleasure. Thanks, everybody.